I'd like to welcome everyone to our webinar this morning, and thank you for joining us today. For a lot of you, I know that you participated in several of the other webinars that we've had, but just for formality's sake, I'm Vicki Clark, President of the Cape May County Chamber of Commerce, and glad that you can be here with us today. It's our pleasure to have this webinar this morning with Fox Rothschild Attorneys at Law, and welcome with us Eileen Muscat and Catherine Barberi. They're representing the offices of Fox Rothschild Attorneys at Law, their Atlantic City and Philadelphia offices. We don't have a whole lot of preliminaries that we go through with our webinars because I know all of you are very busy trying to work through all of the difficulties that everyone is in during this COVID-19 situation. And I don't want to hold you up from that today. We want to hear everything that Eileen and Kathy have to tell us about the Families First Coronavirus Response Act. So with that, I would like to introduce and welcome our chairman of the Cape May County Chamber, Doug Burke, for just a few comments. So Doug, welcome this morning.
Good morning, Vicki. Thank you. Briefly, I just want to thank the whole chamber team, Vicki and Nina, and entire staff for all the hard work they've been doing. We have an exciting lineup of webinars this week, and we're kicking it off today with the Families First Coronavirus Response Act. And, you know, kind of as a business owner myself, you know, there's a lot of complexities going on out there, and we're excited to have Eileen and Catherine here today to help answer some general questions on that topic. And with that, I will ask Nina to, I think everyone's familiar, but give some instructions on the Zoom call. Thank you, everybody.
Thanks, Doug, and welcome everyone. So how we're going to work things today is that everyone except our speakers will stay muted, so you can hear us, we can't hear you. The way that we'll be taking questions today is through the chat box. So you can find the chat at the bottom of your screen. If you're on a computer, you move your mouse, you'll see a Zoom toolbar at the bottom of your screen. You can click chat and type your question there. You can go ahead and send your questions to everyone in the public chat. There's no need to send them just to me or to anyone privately. Go ahead and use the public chat for your questions. If you're on a smartphone or tablet, you may need to tap your screen to see the Zoom toolbar, and then you'll be able to select chat and type your question. Something just a little bit different for today is that we won't be waiting until the end of the presentation to take your questions. So if you have a question on a specific topic as our presenters are talking, if you have a question about something they're saying, you can go ahead and type your question at that time, and we'll do our best to monitor the chat and have them answer your question as the presentation is ongoing. So certainly, you know, you're welcome to submit a general question for the end of the presentation, but you're also welcome to submit something that's relevant to the topic that they're talking about at any given time. Certainly, if you need any help with the Zoom platform, you're welcome to chat me privately or raise your hand using Zoom or otherwise get my attention, and I'll do my best to help as we go along. And with that, I will hand it over to our presenters.
Hi, everyone. My name is Eileen Muscat, and I am with the Atlantic City office of Fox Rothschild. I am the office managing partner in that office, and I practice in the area of litigation. I provide employment and counseling advice for a variety of clients in the area and across the country. I also am a litigator that handles mass tort litigation for pharmaceutical companies. And my co-presenter, Catherine Barberi, she is the co-chair of our Labor and Employment Practice Group. And Catherine is stationed primarily in our Philadelphia office, but collaborates often with us in the Atlantic City office and has many cases in this particular region as well. And so we're really happy to be with you today and try to walk through the Family First Coronavirus Response Act and answer any questions and concerns that you have. We're hoping that going through this process and explaining what the parameters of the Act are will help to alleviate any concerns that you have and really hopefully answer your questions in advance. The boring slide that I have up for you now is our disclaimer slide. The most important part of the disclaimer is that these materials may change. So if you look at these materials 2 weeks from now, they may not be accurate. Things may have changed in the interim. So it's very important, and we're going to give you some resources at the end of the presentation, but it's very important that you keep up to date on the changes in the law and the changes in the interpretation of the law as these issues develop on really a daily basis. So the Family First Coronavirus Response Act, is this really what the doctor ordered to save the businesses? I don't know if that is what the doctor ordered. In fact, what I think that the purpose of the Coronavirus Response Act was really to help the employees. It was to provide them with some immediate assistance so that they could not have to necessarily choose between their work-related demands and the demands of either caring for themselves or caring for someone else. So COVID-19, this is something that none of us knew about 4 months ago. I don't know that really we were concerned about this or thought that it was an issue that was going to completely consume our lives in the way that it has. In looking at the statistics this morning, Cape May County has a total of 212 cases and has had 10 deaths. Atlantic County, a little bit higher, we've had 410 cases in Atlantic County and 11 deaths. But in stark comparison, our neighbors in Bergen County have had 13,011 cases and 550 deaths, and Hudson County is a close second with 11,150 cases and 277 deaths. So by all accounts, this is a very significant and serious issue that we're all being confronted with. And as a result of the highly contagious nature of this virus, we have all been confronted with quarantine and isolation. As you can see, I'm working here from my home, as is Catherine. I don't go into the office anymore. We have a few key people at Fox Rothschild that are there just to basically accept and scan mail and get out things that we need to send to the courts or to clients. And I'm sure that all of your businesses are either closed or you are open because you're essential and you're practicing the necessary parameters of social distancing and enacting the different protections for your employees. Now, on this particular slide, we're going to pass this over to Kathy, and she's going to talk to you just briefly about the CARES Act.
So, good morning, everyone. The thrust of today's presentation really is on the Families First Coronavirus Response Act, which I'll probably just refer to as Families First. But we also want to talk a little bit about a sister act, which is the CARES Act, which stands for Coronavirus Aid, Relief, and Economic Security. The CARES Act was really also intended to address relief for both businesses and individuals who are impacted by COVID-19. In particular for employers, of note is the fact that it makes significant changes to unemployment compensation. So what it does is it essentially adds on additional benefits and additional timeframes that people can receive unemployment compensation benefits. So for up to 4 months through the end of July, employees who are eligible for unemployment compensation in New Jersey will be able to recover both their typical New Jersey unemployment compensation benefits plus an additional $600 per week above and beyond the state benefit. The CARES Act also provides that employees who are eligible can also recover unemployment compensation benefits for an additional 13 weeks through December 31st, 2020. For the first time too, the CARES Act also makes unemployment compensation benefits available to those who are self-employed, independent contractors, freelance employees, and gig workers. This is of course a big change. In the past when we were addressing claims for unemployment compensation, we would obviously take the position that someone who was, for example, an independent contractor would not be eligible. Now under the CARES Act, it explicitly provides for benefits for those folks. Understand that these unemployment compensation benefits, the additional benefits, are going to be funded by the federal government. The CARES Act also incentivizes states to waive essentially the 1-week waiting period that typically applies for unemployment compensation benefits. And it does that by funding the cost of those additional benefits. What some of us may think about when we think about the CARES Act is really the small business loans that are available under that law. My understanding is a lot of those loans have already been maxed out, but CARES Act essentially provided for loans for small businesses with fewer than 500 employees. There was a higher limit or revenue limits for certain employers in certain industries, and the businesses would be eligible for loans of up to $10 million. Again, my understanding is at this point, I believe those loans are pretty much maxed out, but it's my understanding that apparently there's supposed to be a second round of funding happening soon. The CARES Act also provides for loan forgiveness for certain of the small business loans, as well as tax credits in connection with those loans. The Families First law also has some impacts on unemployment compensation benefits. In particular, the federal government, in an effort to open up unemployment compensation benefits, has essentially incentivized employers to provide those benefits. And what the federal government has required of employers is that and states, is that they waive the waiting period for unemployment compensation benefits. So states that want to essentially be able to take advantage of the additional CARES Act unemployment compensation benefits need to waive their typical waiting period for those unemployment benefits. They also need to waive the work search requirement. So typically employees are required for the full duration of their unemployment benefit receipt to basically certify that they're out looking for other work. The federal government has essentially required that work search requirement be waived and then for a period of time lessened for people who are impacted by COVID-19. And part of the Families First law also indicates that, again, there's not going to be a charge to most employer accounts for the COVID-19 related benefits. So essentially the federal government is funding those increased benefits. Self-insured employers, like many nonprofit organizations, will still be charged to the extent that they don't already pay into the unemployment insurance. Also, again, the federal government, in an effort to incentivize states and employers to make these benefits more available to employees, is also requiring the states to improve access to benefits. You have to ensure at least 2 methods of application: phone, internet, and/or in person. I'll tell you that New Jersey has already done these things. So to the extent that your employees have been applying for unemployment compensation, they will find that the waiting period has been waived, et cetera. In terms of unemployment compensation benefit eligibility, I already talked about the fact that there is a whole other class of employees who are now eligible under the CARES Act. But now to become eligible for unemployment compensation benefits, really the employee just needs to suffer essentially any loss of income. So typically we would think about employees being eligible when they were laid off, when they were terminated, for example, for reasons that did not arise to the level of willful misconduct. Now, to the extent that an employee has either reduced hours or a salary reduction in connection with COVID-19, in most states, they would be eligible for unemployment compensation, and they would be eligible in New Jersey for that. There are some thresholds in terms of how low the salary reduction needs to go before someone's eligible, but for the most part, employees will have that eligibility. Also, to the extent that employees are furloughed, and by furlough, we generally mean employees who are on essentially an unpaid leave of absence, but who continue to be employed, they would also now be eligible for unemployment compensation benefits under the Families First Act. And of course, employees who are laid off in connection with COVID-19 are eligible as well for those benefits. There is a requirement now that to the extent that employees suffer any of these losses of income, the reduced hours, the salary reduction, furlough, or layoff, that employers give them notice of their unemployment compensation benefit eligibility. I think it's a best practice always, if you are doing one of these things, a salary reduction, a furlough, et cetera, that you notify the employees in writing that they should immediately apply for unemployment compensation and provide them with all the information that they need in order to do that.
So we have a couple of questions coming in. Is it okay to ask them now?
Sure.
Okay. If an employee can do a job from home and is being paid for 20 hours a week, are they eligible for 2 weeks paid family leave and then 10 weeks at 2/3 the normal pay?
Let's defer that question because I know that Eileen and I are going to get into that detail in a moment. Right now, I'm just talking about the unemployment compensation benefits. But the
Okay.
person who asked the question is correct that there are potential sick leave and family leave benefits, but I want to first introduce that topic and then we can answer that question.
Okay. So we have another one here. If an employee is a member of the CDC high-risk group and does not go to work based on the prescribing recommendation, how are they to be compensated?
Okay, so that's also something that I think we should address when we start talking about sick leave, because there is the potential for that individual to be eligible for sick leave for essentially either caring for themselves or caring for a family member. It's kind of outside the scope of the unemployment compensation, but we will certainly address that in a moment.
Okay. And any word on when extensions will be available when the benefits are exhausted?
So if by that they mean unemployment compensation benefits to the extent they're exhausted. So right now in New Jersey, typically you would have been eligible for up to 26 weeks of unemployment compensation. The CARES Act has expanded that out an additional 13 weeks, bringing it to 39. It's not clear that that will be further extended. I think we're in sort of a wait and see mode to see, hopefully the country will have gotten, for the most part, this pandemic under control by the end of the year. So we're not aware of any further extensions, but I think that remains to be seen.
Okay. All right. Thank you.
Sure. So in terms of handling the unemployment compensation surge, so there were some 16.8 million unemployment compensation claims filed nationwide for the period of March 15th through April 4th, which is extraordinary. Unemployment rates are edging higher and higher, and that's reflected in the unemployment compensation filings. In the week ending April 4th, some 213,897 New Jerseyans filed for unemployment compensation. That's, believe it or not the highest state, but it's certainly a substantial number of unemployment compensation applications. There have been some issues, and I think these are lessening as well, with people having difficulty getting onto the websites and getting certainly through on any kind of hotlines in order to inquire about the status of their unemployment benefits. Of course, you should encourage employees to keep trying. I do know that there's been some delay as well in unemployment compensation checks being cut. That's understandable. There's just a huge number of claims that are being processed right now in New Jersey. So employees should be encouraged to hang in there and keep applying. Eileen?
Sure. So all of these things coming together really result in some tough choices for employers to conserve cash and to maintain the viability of their business. So the Family First Coronavirus Response Act was enacted March 18th of 2020 and went into effect April 1st. So it has been now in effect for 20 days. And these are some of the choices that employers are confronted with, which may trigger some issues concerning Family First, which we will go over with you in detail. So some of your options to conserve cash as an employer would be to reduce hours and cut pay. And all you need to do is look online, look at the news, read the paper, and you'll see that the majority of employers are doing just that. They're also reducing salary. So they're taking the salary of employees and reducing it overall. Be very careful though, because you have exemption related issues. So if you have an employee that's exempt based on the salary basis, based on what it is that you're paying them per week, which I believe now is $630 per week. Kathy, is that correct? Yeah, I think so. So if you drop below the salary basis, you would then lose the exemption for that employee. So just be careful. If you're on the edge in terms of an employee with their salary, make sure you check with a legal professional before you do that, and at least weigh the pros and cons of doing that so that you know what you're going to be dealing with in terms of exemption related issues. Another option would be furlough or layoffs, and we'll cover each of these in a little more detail. So reducing hours or pay. If you reduce an employee's hours or pay, as Kathy indicated, they will be eligible for unemployment compensation. They will maintain their full attachment to the employer, and they will be eligible for Family First benefits. There is also no requirement to pay them out for accrued paid time off or accrued pay. They may lose their eligibility though for health benefits. So you certainly should check with your healthcare provider and see if there is a requirement in terms of the number of hours the employee is working to be eligible for benefits. Because if they do drop below those number of hours, that would trigger your COBRA requirements, and you would need to send COBRA notifications to your employees. The other option is furlough, and sometimes people and employers use the term furlough and layoffs interchangeably. They are slightly different. So a furlough is really a temporary layoff. It's more of a temporary short time period that you're furloughing or letting the employee not work for a period of time. During the furlough, the employee is eligible for unemployment compensation. Again, they maintain their attachment to the employer. You've not fully separated them from employment. And it's easier to ramp people back up because you don't have to go through the whole hiring process again if you've laid them off and then rehired. They would not be eligible for Family First benefits because if you're furloughing the employee, that means there's not enough work or business to sustain the employee. As we'll go into in more detail, you're not eligible for Family First benefits unless there's work available, either in person or by teleworking. Again, there's no requirement to pay out accrued pay unless the company policy provides otherwise. And again, you may lose the eligibility for health benefits. You need to check with your insurer. Some insurance policies would allow for a certain period of time for the employee to be furloughed and still covered under the insurance. But again, that's going to be an individual determination based on your policy. In addition, there's no WARN exposure. WARN is the type of notice you have to give for a mass layoff. There is no WARN exposure if the layoff will be less than 6 months. Layoff is a more permanent process. That means you're letting the person go. There's no promise they're coming back. And in that circumstance, again, they're eligible for unemployment compensation. They would not be eligible for Family First benefits. Again, no requirement to pay accrued paid time off unless there's a company policy providing otherwise. And they would completely lose their eligibility for health benefits because you're severing them completely from the employment relationship. With respect to layoffs, you do need to make some certain considerations with respect to WARN notices. Now, there's a both federal and a New Jersey WARN Act. Under the federal WARN Act, WARN notice may not be necessary because of unforeseen business circumstances. And under federal WARN, you don't have to give any type of notice if you're laying people off because of an unforeseen circumstance. We would certainly argue that this coronavirus was unforeseen, but there is a question that would come up as to whether or not, as time goes on, if it remains unforeseen. It's here, it's not going anywhere. We're hoping it's getting better, but we now do have some knowledge about that. So again, if you're subject to WARN, which would mean you're an employer of 100 or more employees, you should consult with a legal professional with respect to your potential exposure to WARN notice requirements. New Jersey also has a WARN Act, of course, and New Jersey's WARN Act, when it goes into effect with the amendments, is going to be a little more stringent than the federal requirement. Now, just last week, Governor Murphy did sign an amendment to the New Jersey WARN that was immediately passed by both legislators. And that specifically states that a mass layoff will not include, will specifically exclude layoffs necessitated by national disasters. There's a bunch of other parameters, but that's the one that I think is most applicable to our current circumstance, whereas before the New Jersey WARN did not have that exception, so employers were grappling with whether or not they needed to also send some type of WARN notice if they expected the layoff to be longer than 6 months in duration. Governor Murphy thankfully also delayed the implementation of the amendments to New Jersey WARN. It is going to be 90 days after the stay-at-home order is lifted. So that's critically important because New Jersey WARN is going to require payment of severance, even if you give a timely notice. So again, if you're going to be confronted with mass layoffs and you have 100 employees or more, you're going to want to seek some type of legal advice with respect to those layoffs to make sure you don't run afoul of New Jersey or federal WARN, because there are penalties and fines and other potential exposure.
So let's look at employer coverage and which employers are actually covered by the Families First law. So when we talk about private employers, under the Families First law. It's those with under 500 employees that are actually covered. So it really applies primarily to those that are considered small to mid-size. I know there's been a lot of questions about why that's the threshold that was adopted. I think the going theory is that it's because it was assumed that the larger corporations would in fact already have some kind of paid sick leave provisions in place, whether that was true or not. Also, governmental employers are going to be covered by the Families First law. One of the things that I get a lot of questions about, and I think Eileen addressed at the beginning, is some of my smaller employer clients say, well, we're not covered usually by the Family and Medical Leave Act. We have fewer than 50 employees. Are we covered by Families First? The answer is yes. If you're a private employer with fewer than 500 employees, regardless of whether or not you're typically covered by the Family and Medical Leave Act, you are covered. There are some exceptions as to employees who would not be covered. There's certain federal government employees who are not covered. And moreover, employers who employ healthcare providers or emergency responders may also exempt those employees from the requirements of the Act. And I'll talk about that in some more detail shortly. In terms of which employees you do count in determining whether or not you've got 500 or fewer than 500 rather employees, you do look at full-time employees, you look at part-time employees, you would also look at employees on leave. So just because someone's currently on a leave of absence doesn't mean that you would exclude them from calculating whether or not you meet that under 500 employee threshold. You would also look at temporary employees that are jointly employed. So a lot of times this will come up in a situation where there may be affiliated entities or a subsidiary that has an employee perhaps who's jointly employed between both entities, or more frequently in sort of the staffing agency situation where an employer may have a temporary employee working for them that in fact would be considered jointly employed for purposes of the Act. So please be careful in ensuring that you're really counting everyone who should be counted. Again, day laborers who are supplied by a temporary placement agency are also going to be included for purposes of computing the fewer than 500 employee threshold. You would not, however, include employees who are working outside of the US in making that calculation. As I mentioned a moment ago, there are some exemptions in terms of coverage. One that would apply to particularly small businesses, that is businesses with fewer than 50 employees, may be exempt from the requirements, certain requirements of the Families First Act. In particular, if the small business can show that providing leave to employees to care for children would jeopardize the viability of the business as a going concern. In terms of what one would look at in order to determine whether or not that small business exemption applies to the small employer, you would really need to look at whether the expenses and financial obligations exceed the available business revenue or cause the employer to stop operating even at a minimal capacity. You would need to look at whether or not there's a substantial risk to the financial health or operational capacity of the business due to the fact that they can't retain or have on staff employees with the specialized skills and knowledge and responsibilities that they would typically require. Or the small business would need to show that they just can't find enough workers who are able, willing, and qualified. And as a result, their status as a going concern would be threatened. I would advise that if you are a small business and you are inclined to take advantage of the hardship exemption, you need to very thoroughly document that financial status. You're not encouraged to send anything to the Department of Labor. It's really that you as an employer need to be prepared in the future to essentially defend the fact that at the time, you would not have had the money or the right employees essentially to proceed as a going concern. So again, I would strongly recommend that if you want to proceed under this prong, you document it thoroughly and work with your financial advisors to ensure that you meet this exemption.
Kathy, I have a couple of questions about FMLA. Can I ask them now?
Sure, let's see what they are.
Oh, okay. Currently, FMLA provides up to 12 weeks of job protection. During this pandemic, is it calculated at 10 weeks? Are those separate or in place of?
Okay, So yeah, I'm going to talk about that in a moment. What you'll hear is that total, an employee has 12 weeks per year, and we'll talk about what a year means also, of a combination of family and medical leave and whatever they're eligible for from a family leave perspective under the Families First Act. So it is going to be a combined total, and I'll talk about that in some more detail in a bit.
Okay, and then how are employees counted? Each person or using full-time employee, and if it's full-time employee, by which formula, the IRS, the ACA, etc. Even if they only worked a short period of time, say 4 hours one day in the case of a seasonal employer with transient employees.
Yeah, so for purposes, I'm assuming they're talking about if they're trying to figure out whether or not they're covered by the Families First Act, that is whether they have fewer than 500 employees. You would count each of those types of employees as one. So there's not sort of like a, as I understand it, a percentage or something that would apply to part-time employees. And so if you, I don't want to go back now, but you'll recall that a moment ago I talked about you'd count full-time employees, you'd count part-time employees, you'd count temporary employees. Each of those would count as one for purposes of that calculation, essentially.
Okay.
So I want to talk a little bit too about exemptions for healthcare providers and emergency responders. I mentioned a moment ago that employers of healthcare providers and emergency responders may decide to exempt those employees from the requirements of the Families First Act. In terms of who is considered, for example, a healthcare provider, the definition is pretty broad. And so it includes employees employed by nursing facilities, doctors' offices, hospitals, healthcare centers, clinics, as well as certain employees of entities that also help support those healthcare institutions. So if you believe that any of your employees may be healthcare providers or emergency responders, I'd recommend that you take a look at the FAQs that were released by the Department of Labor. They provide a lot of detail about who could potentially be exempted, and you want to take a look at that before you make that decision. Again, the terms are defined broadly. Whether or not the employees should be exempted is really within the discretion of the employer. However, again, you need to be guided by the Department of Labor's FAQs in making that determination. The other thing that the Department of Labor has encouraged is you really want to sort of tread lightly when applying the exemption, meaning the goal here, of course, is to make sure that people get paid, in particular for periods of time in which they are ill. So while your employees may be exempt, the Department of Labor encourages employers to think about potentially at least making available to employees the 2 weeks of paid sick leave that we're going to talk about if the employee is in fact ill. So you can, as an employer of healthcare providers, essentially say, I'm going to exempt you from the requirements, for example, of the family leave portions of the Families First Act, but I am going to permit you to use 2 weeks of paid sick leave. And so why don't we, Eileen, talk a little bit more about what Families First actually provides for.
Sure. So as I had said at the beginning of the presentation, the way that I look at this is it's like an extension of the Family Medical Leave Act. So now you're providing additional reasons for which you would qualify for the for leave under the FMLA. And as you can see here, there's 6 total reasons. We're going to go through these 3 reasons here. These are the reasons for paid sick leave. So some of the reasons include, so the employee is unable to work, including telework. So if the employee can perform their job from home, they're not eligible for this leave. So the employee is unable to work, including telework, because, number 1, they're subject to a federal, state, or local quarantine order. And it's only if the employer had work for the employee to do. So if the employer, again, as we covered in the beginning, if the employer has no work for the employee to do, they're not eligible for leave. Number 2, they've been advised by a healthcare provider to self-quarantine for COVID-related reasons. And that has to be, so that the healthcare providers believe that the employee has or may have, or is particularly vulnerable to COVID-19. And I know that that came up earlier in one of the questions. So if a healthcare provider has advised that the employee is particularly vulnerable to COVID-19 and as a result needs to self-quarantine, they would qualify if there's work available by the employer. And number 3, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Off camera, both Kathy and I have tissues because it's allergy season. So some of the allergy symptoms are very similar to COVID-19 symptoms. So the employee has to be experiencing symptoms and they have to be seeking a medical diagnosis. It's not enough for them just to say, I feel like I have it, or I have COVID-19 and I'm afraid that I have it. They actually have to, in addition, seek a medical diagnosis. And again, all of these are only applicable if the employer has work available for the employee. Moving on, this is also other reasons for paid sick leave. And now these are reasons because you're caring for someone else. The employee is unable to work because they're caring for someone who is subject to quarantine. They're caring for a son or daughter if the school or place of care is closed or unavailable due to COVID-19. And then finally, the catch-all, experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services, Labor, or Treasury. Unfortunately, we don't have any specifications yet as to what these conditions might be. But again, they've provided this catch-all in case something comes up in the future, so we can keep an eye out for any guidance on that particular topic. Now, what type of paid sick leave is available? We can go through it in a little more detail. So again, caring for yourself. If you're ill, and for one of those first 3 reasons that I provided, you get 2 weeks of paid sick time up to 80 hours. And that is compensated at the regular rate of pay if the employee is unable to work or telework. And again, it's for those 3 different reasons we specified. The employee is subject to a government quarantine or isolation order, and or the advice of a healthcare provider, or is experiencing the COVID-19 symptoms and seeking a medical diagnosis. Other types of paid sick leave available, again, caring for others. Again, you get 2 weeks up to 80 hours of paid sick time, but it's at 2/3 the regular rate of pay, and that's when you're caring for someone else. Again, it's for the 3 different reasons we've provided here. They're unable to work because they have a bona fide need to care for an individual subject to the government quarantine or isolation order, or someone who's being isolated on the advice of a healthcare provider, or to care for a child under the age of 18 whose school or child care provider is closed or unavailable due to reasons related to COVID-19. Now, the duration of the emergency paid sick leave, how long can the employee take paid sick leave? Now, for the leave related to the employee's quarantine or symptoms, full-time employees get 80 hours, and part-time employees, they have their averaged hours worked over a 2-week period. And that's how, it actually is a more complicated process to make that determination. And there's some specifics in the regulations that explain exactly how you make that calculation. But in essence, you take the average hours they've worked over a 2-week time period, and that's how much time they would have available. Kathy?
Sure. So in terms of what type of paid family leave is available in the instance of emergency childcare, that would be up to an additional 10 weeks of paid family leave. The assumption being that for the first 2 weeks, the employee would have been on the paid sick leave that Eileen just described. During the emergency childcare leave portion of the benefits, and again, this is under the family leave portion of the Families First Act, the employee would receive 2/3 the regular rate of pay. In order to qualify for this, the employee needs to have been employed for at least 30 calendar days with the employer. And the employee needs to be unable to work due to a bona fide need for leave to care for a child whose school or child care provider is closed, or if the child care provider is unavailable for reasons related to COVID-19. In terms of the duration of emergency paid family leave, when we're talking about leave related to caring for a child, it is up to 12 weeks. Again, the 2 weeks of paid sick leave would come first, followed by 10 weeks of paid expanded family and medical leave at up to 40 hours a week, depending upon the employee's usual schedule. For part-time employees, again, the number of hours that the employee would be entitled to would be based upon how many they're normally scheduled to work over that time period. Understand too that if you've got employees who work varying schedules, you want to take a look at the FAQs and regulations and know that you would essentially calculate it based upon the average number of hours per day over the 6 months preceding the date on which the leave began. So be careful if you've got people working a varying schedule that you take a look at those specific requirements. And then this comes back to the question that I was asked earlier about how you figure out how much FMLA someone's entitled to when they've also got potentially family leave expansion benefits available to them. So as I indicated before, when you've got FMLA entitlements and you're also entitled potentially to family leave expansion under the Families First Act, that's going to be for a total of 12 weeks. It's not 12 weeks of FMLA plus 12 weeks of families first leave. If the employee has already used FMLA in the last 12 months, they're only going to be at that point eligible for the remainder of their 12-week entitlement that they've not already used. Please be careful when you're computing eligibility that you take a look at your policy and see how you've defined the FMLA year. So I generally recommend that employers have a policy under the FMLA that talks about a rolling 12-month period. Just be careful that you are acting consistent with however you've defined your year for FMLA purposes in your act. The other question I've gotten a lot is whether or not you've got 2 employees working for you, both of whom may be eligible for expanded family leave under the Families First Act, whether they might both be essentially confined to just 12 weeks total between them. For those of you who are covered under the Family and Medical Leave Act, you know how that works under that act, which is to say if you've got 2 employees working for the same employer under the FMLA, they can only use a combined total of 12 weeks. I've not seen any guidance to suggest that that 12-week total restriction also applies to spouses seeking family leave under the Families First Act. So I would say for now, you should assume that 2 spouse employees would each have their own separate 12-week entitlement under the Families First Act.
So here we're providing you with a summary chart, and hopefully this allows you to see in detail what we were just speaking about and how they overlap with one another. So again, the reasons for the leave are on the left, and at the top you have the different type of leave available. So you have the emergency paid sick leave of 80 hours, and then the emergency child care, and then we're going to go into a little detail now in terms of the wages, but there's also a maximum cap, and we're going to talk about that briefly with you now. So is there a cap on the amount of leave pay an employee can receive? Yes, there is. So for the emergency paid sick leave, there are both daily and aggregate caps. Leave for COVID-19 symptoms, again, quarantine or symptoms caring for yourself. It's the regular rate or applicable minimum wage, whichever is higher, but it's capped at $511 per day or $5,110 in the aggregate over that 2-week period that they're on leave. With respect to emergency paid family and medical leave, again, caring for others for their medical reasons, there's both daily and aggregate caps. So the leave related to caring for someone subject to the quarantine order or self-quarantine, that's at 2/3 the regular rate of pay or 2/3 the applicable minimum wage, whichever is greater, but it is capped at $200 per day and $2,000 in the aggregate over that 2-week period. Again, the final reason, this is the emergency paid extended family leave. This is the extended 10-week time period that the employee can take to care for their child. There are both daily and aggregate caps. It's 2/3 the regular rate, again, or 2/3 the applicable minimum wage, and it's up to $200 per day or $12,000 in the aggregate for that full 12-week period.
So sure. So just like for those of you who are covered by the FMLA, you would require certain employee notice requirements. So too does the Families First Act require employees to provide certain notice. Where the need for leave is foreseeable, the employee must provide notice as soon as practicable. In point of fact, I think most situations now, particularly if someone is ill with COVID-19 related symptoms, you're probably going to get somewhat shorter notice, and that should be accepted by the employer. If the employee is taking leave because of the absence of childcare or their school is closed, The employee really need only provide reasonable notice, including the name of the child, the school that they attend, and also essentially a certification that no one else is available to provide that child care for the child. And typically by that we mean another spouse or partner. If in fact the employee is taking the position that they have been quarantined by a government entity, they need to provide the name of the government entity. If it's they're in isolation due to an order from a healthcare provider, they should provide the healthcare provider's information. And just like you would under the FMLA, you would provide essentially the same kind of information that one would provide due to their own illness as you would provide under the FMLA. So, you know, what's the nature of the condition, what's the duration of the condition, and you can require documentation from a healthcare provider. Be aware, however, you know, that both the CDC and the Department of Labor have cautioned that given the overload on our healthcare system, it may take some time to get some kind of certification or note from a physician confirming that someone is ill. So I would suggest, just as those entities have suggested, that you give employees some additional time to provide that documentation than you might typically provide. In terms of how the Families First Act leave provisions coincide with any existing leave that employees already have, an employee may elect to substitute accrued vacation leave, personal leave, or medical or sick leave, as well as anything that may be mandated by state or local governments. Note that I said may, in that employers cannot require, coerce, or unduly influence employees to first use whatever paid leave they may have available. Understand that essentially the paid sick and family leave provisions of the Families First Act are going to provide leave on top of any other leave right or paid time off, for example, an employee may have available to them from their employer. If the employer and the employee agree, the employer can supplement portions of the Families First leave where the employee is not being paid their full benefit. Again, they would have to agree to that. So for example, during time periods in which an employee is being paid 2/3, the employer and the employee may agree that they can use part of their PTO to essentially make up the difference and bring it to full pay. The key here is not to force employees to do any of this. So keep that in mind when you are complying with the Act. And then intermittent leave. Intermittent leave can be available to employees. The Department of Labor has really differentiated between intermittent leave that's available to someone who is teleworking and someone who might actually be in the workplace. So an employer and an employee can agree that to the extent that the employee is teleworking, they can take their leave on an intermittent leave basis for essentially the full leave eligibility. And that makes sense, because of course an employee who's working from home is not risking infecting anyone else in the workplace. And they may be just needing certain time off, but not full time off in order to recuperate or get treatment, et cetera. And that's fine, again, in the teleworking environment because they're not putting anyone else at risk. However, for employees who work in the workplace, they really are not permitted to use intermittent leave for self-care. That would be those reasons 1 through 3 and 6 that Eileen went through at the beginning of the presentation. Nor can they use intermittent leave to care for some other person who is or may be infected with COVID-19. Again, the rationale is here that we don't want someone who is ill or caring for someone who is ill to be in the workplace, causing potential infections for others there. So just be mindful of that when you're talking about intermittent leave options with your employees.
Now, please keep in mind that you may not require the employee to find a replacement worker to cover their duties and responsibilities while they're on emergency paid sick leave. I know that that sometimes can be a policy internally for an employer, that if you're going to be out, you need to get someone to cover for you. That is specifically addressed in this act, and it says that an employee need not obtain someone to cover their shift for them or to cover their responsibilities. That's not the employee's responsibility. That would be the employer's responsibility. Continued health care coverage. So under Families First, the employee is entitled to continue their health care coverage under the same conditions as if they had not taken leave. So as we had spoken about at the beginning of the presentation, when an employee is furloughed or reducing their hours, that may impact their health coverage. That does not apply for employees taking leave under Families First. If they take leave under Families First, they're entitled to maintain the same coverage they had whether they were on leave or not. The employee, however, would remain responsible for paying the portion of their plan premium as they paid before. So just like if someone that's on FMLA, if you all have dealt with FMLA in the past. I hope that none of you have open enrollment right now, but if you did have open enrollment while employees are out or while you're dealing with the pandemic, whatever coverage they normally would be electing is what they would be entitled to continue while they're out on this leave. Now, what do you do when the employee is returning from leave? So there's two different procedures for that. So if you're an employer with 25 or more employees, you need to return that employee to the same or equivalent position. And so that is kind of mimicking or following the same model as the FMLA. So you need to make sure that the employee is returned to the same or equivalent job. Now, if the employee would have been laid off due to reasons unrelated to the leave, they are not protected. They are still subject to that leave and layoff. So the fact that they're on the Family First leave does not cover them in a zone of protection and does not immunize them against being subject to some type of layoff if other employees similarly situated are also being laid off and they would have otherwise been laid off. Now, please keep in mind, though, that the burden will be on the employer to show that that employee would have been laid off and not rehired regardless of the leave. With respect to employers with less than 25 employees, those employers must make a reasonable effort to restore the employee to an equivalent position for an ongoing period. And it looks to me that that's for about a year. And you count that time period from the time the employee comes back to work. You need to make sure that you make an ongoing and reasonable effort to restore that employee to an equivalent position. So you're not completely exempted from returning that employee to the same or similar position, but you have an ongoing requirement to continue to find a job for that employee that's equivalent to what they had when they went out on the leave.
So one of the things that the
Kathy,
Families First Act, one of the things that the Families First Act provides for is an employer tax credit. I get questions about whether employers can receive reimbursement for payment of paid leave, and the answer is yes. 100% of that is refundable as a tax credit with reimbursement as a credit essentially against your Social Security and Medicare payroll taxes. To date, I don't believe the U.S. Treasury has developed a more sophisticated mechanism for accelerating reimbursement to small businesses, but I would strongly recommend that you coordinate with your financial folks or your accountants to make sure that you take advantage of this tax credit to the extent that you've provided employees with paid leave under the Families First Act. And also be aware that there is a required notice of rights that employers that are covered by the Families First Act need to post. Typically, you can post it where you would post your other notices. So if you are providing, posting your various, for example, New Jersey and federal legal notices in your break room or wherever else you may do it on site, you can do it there. That said, the Act also provides for providing those notices via mail or on the intranet or via email. And if your employees are all working remotely, I would strongly recommend that you make the notice available to them either in email or on the intranet so that there's no question that they in fact received the notice. The question I've also gotten frequently is, we are covered by the Families First Act, but we've exempted our employees because they're healthcare providers. Should we still post the notice? I've said yes to that. I think if you are an employer that is covered by the Act, regardless of whether you then decide to take advantage of the small business exemption or the healthcare provider or emergency responder exemptions, I would still recommend posting the notice so that there's no question that you took it, that you complied with that provision.
Okay, enforcement, and we're going to try to quick wrap this up. We have a couple more slides, but we'll try to flip through these fairly quickly. So employers may not discriminate or retaliate against their employees who have used their paid sick time or paid family leave, or who have taken any other type of protected or engaged in any other type of protected activity. And you need to be very careful because there's very specific remedies for failure to pay, for failure to provide paid sick time. There's going to be FLSA, which is the Fair Labor Standards Act remedies, which means fines and things like that. In addition, same thing under the Family Medical Leave Act. If you fail to provide the paid family leave, you're going to have the remedies available under the FMLA. And that includes private right of action against the employers. Now, you need to know that there was some initial guidance that there would be a delayed enforcement of this act for the first 30 days, but that expired on April 17th. And during that time period, if employers made a good faith effort to comply, but they made a little minor mistake or a misstep in some way, there is indication that that will not be enforced against the employer. But you should make every effort to comply in full detail now. Now, could all of this change? Of course, and I mentioned this at the very beginning of the presentation, so you should regularly monitor the Department of Labor's FAQs on their website for additional guidance, and we've given you the specific links so that you can get to that section. We also have a coronavirus resource page, and we update that on a very regular daily basis, and we provide additional interpretation and alerts as to developments with respect to the law, and not just with respect to Family First, but in all different aspects of the law that are being impacted by the coronavirus. Now, with respect to the New Jersey earned sick leave, again, if employees have any earned sick leave left this year, they can use that now. They could use that for the 2 weeks of technically unpaid emergency child care leave, which they could also use under the Family First. But keep in mind that you should not be requiring that employees use their New Jersey earned sick leave. It's something that they can choose to use after Families First. In addition, please be advised that if the employee is out on leave under Families First, they are not accruing their New Jersey earned sick leave. So employees that are not actively working do not accrue additional earned sick leave if it is that you require your employees to accrue time as opposed to front loading it at the beginning of the year. You can't take it away once you've given it to them up front, but they don't accrue if they're not actively working. We also have the New Jersey Family Leave Insurance. Again, after exhausting the federal paid leave, employees may obtain 6 weeks of leave through the New Jersey Family Leave Insurance. And as you know, that pays 66% of their average wages and is capped at $667 per week. And this can be used either before or after unemployment. So again, this is another possibility for employees who are being confronted by leave-related issues during the pandemic.
I've talked a fair amount about New Jersey unemployment compensation and the fact that it provides up to 60% of average wages. That's obviously going to be combined with the additional entitlement under CARES. It does provide currently New Jersey unemployment for a maximum of $713 per week. And again, employees will also be able to take advantage of the additional $600 per week through July under CARES. And as I said at the outset, employees can now get up to 39 weeks of unemployment compensation.
Kathy, we have a question specific to this unemployment benefit, and it applies to employees that work just a little bit. The question is, are part-time employees earning only $150 to $200 a week, so just working a few hours a week? Are they eligible for the additional $600 a week?
I don't read the CARES Act to restrict that $600 per week additional benefit to only employees who are working full time. Again, it may be that the CARES Act, there's some later construction of that does in fact limit that benefit, but my understanding is the employee is going to get their typical New Jersey benefit, which is a maximum of $713 per week. That would apply really to people working full time. So they're going to get a lesser portion of that, plus still the $600 per week under CARES. And I don't think that the CARES Act, to my knowledge, differentiates between part-time and full-time employees for purposes of that additional $600. Again, the goal is to keep people essentially afloat, able to pay their bills so that we can keep the economy going. And I think that that additional $600 is regardless of the hours worked, is my understanding.
Thank you.
I wanted to also just talk briefly about New Jersey temporary disability. Of course, it provides for up to 26 weeks for the employee's own illness. It typically provides for 66% of wages, up to a maximum of $667 per week. This can also come into play when an employee is ill with COVID-19. I would strongly suggest that you take a look at the Department of Labor's website. They have some excellent charts that show how these various types of leave in New Jersey work in conjunction with each other. So please take a look at that and figure out what employees may be eligible for at any given time. And finally, workers' compensation. Employees who do contract COVID-19 at work could be eligible for workers' compensation benefits. You know, of course, that's a benefit that typically would be filed through the employer. So if an employee comes to you and says they believe that they've contracted COVID-19 at work, please go ahead and file that workers' compensation paperwork with your carrier, and they can, of course, make the determination as to whether or not there is eligibility there. And finally, Eileen shared some really helpful resources earlier in the presentation that can give you some additional information about developments concerning the coronavirus. As she indicated, we have a really fulsome website that provides a lot of guidance. We typically do alerts when there are developments in New Jersey or at the federal level that may impact employers during this time. But some excellent additional resources include the Department of Labor, Federal Department of Labor's website. If you go to the link that we've highlighted here, there's some additional information for you. Also, there's OSHA coronavirus guidance. OSHA, of course, is the agency that ensures the safety of employees in the workplace, and they've been releasing a lot of guidance about appropriate cleaning, how they're going to monitor compliance with safety protocols. So please take a look at that. They also link to a lot of the CDC guidelines around cleaning, and I think it would be important for employers to take a look at that as well. And also congress.gov is going to provide you with updates about any contemplated legislation. I know that at the federal level, Congress has been talking about some additional funding packages. So it's possible that we will be seeing some new legislation in the weeks to come. And, you know, finally, I know that there was a question about who is actually enforcing these laws and monitoring that employers are paying sick pay. That's going to be done at a bunch of different levels. So, you know, in terms of the federal requirements, the Department of Labor ultimately will enforce that. But as Eileen indicated, there are some instances in which employees can bring a lawsuit if they believe that they've not been provided with the pay to which they're entitled. So hopefully we've provided you with some helpful guidance today. If you do have any questions or additional concerns, you can feel free to reach out to us, and we'll see if we're able to help you with those. Take a look, stay informed, sign up for alerts from our website. And of course, everyone take care out there. It's been our pleasure today presenting to you.
So we do have a couple more questions. If I could just present them to you. Here's one. An employee who is peak time, working only 20 to 25 hours per week, decides she doesn't want to come to work because she is afraid of catching the virus. She is not able to work from home. Is she able to collect STD? So you may have addressed that, but I'll just share the question.
Sure. So there's a lot of different things that could come into play here. And so, you know, one thing I'd want to know is whether or not the employer is covered by the Families First Act. I'd also want to know whether or not the employee has a legitimate concern because, in fact, they've been identified as someone who is particularly vulnerable to coronavirus infection. If in fact they're covered by the Families First Act and they are particularly vulnerable to infection and they've been advised by a healthcare provider to not go to work on that basis, they may have eligibility for paid sick leave under the Families First Act. You know, in terms of New Jersey potential benefits, if they're not currently ill, I don't see New Jersey, for example, temporary disability applying to them, or workers' compensation. It's possible they may qualify if they have some kind of underlying illness for family, you know, for some kind of, you know, I was going to say family leave insurance, but that would really apply in the instance where they're caring for someone who's ill. I don't see this as a potential situation where they'd be eligible for unemployment compensation if they're making their own decision in the absence, again, of some kind of healthcare issue to stay home. So this is a situation where I would really look closely at the Department of Labor website for New Jersey. They, again, set out, there's some really great FAQs in there where you can sort of take a look, understanding what your scenario is, whether or not the employee is in fact ill with some underlying condition, whether or not you're covered by Families First. And that will give you some guidance at least as to the New Jersey-based benefits that the employee may be eligible for. You may determine that they're not eligible for any of it, in which case they could take advantage of, you know, for example, paid time off if your policy provides for that.
Okay. And finally, about who is monitoring the program for enforcement purposes?
Yeah, Eileen, do you want to take that one in terms of enforcement?
Sure. So that's being monitored by the Department of Labor. And so the Department of Labor would be monitoring that for enforcement. And, you know, I'm sure you're all asking, well, how are they even going to monitor this? There's so many employers and so many issues. Well, they're really good at sending out alerts and notices to employees and asking employees to self-report. So that's normally how they get their tips for investigations, is through employees that report what they believe to be improper conduct by their employers. And I think, I don't recall the specific statistics, but the number of unfounded claims and reports of violations well exceed what the Department of Labor finds has actually been a violation. But that's how it ends up getting started. An employee can report that to the Department of Labor, then the Department of Labor would conduct an investigation.
Okay. Well, thank you very much. It was great information. Your presentation was very insightful, and we appreciate your time and sharing all that with us. Again, I think if anyone has any further questions, here's the information on the screen. You can email Eileen or Catherine, and I'm sure they'll respond very quickly to you, or email us at the chamber. The presentation was recorded. We'll be sharing that with you, and as well as all the slides. And again, wish everyone a great day, and that we'll all get through this sooner rather than later. We keep saying that, and every day we hope that we are one day closer to getting out of our sheltering in place and of this time of not knowing what the next day brings. But thank you all again, and wish you a great day.
Thank you.
Thanks, everyone.